Okay, good. So welcome everyone. I'm Professor Guerra Pujol, and welcome to Module A of the Legal and Ethical Environment of Business. What this is an optional live Zoom lecture. I'm also recording it if you aren't able to make it, but I'll also record it right now. And I want to talk about the sources of law. I want to introduce you to the legal environment by first challenging you to think about what is law. What distinguishes law from other types of rules that we have in the world, and among social groups. And so that's what we'll do today. We'll talk about main sources of law. What I'll also do is I'll talk about three important leading cases: Wilkerson versus Florida, Lujan versus Defenders of Wildlife, and Yates versus United States. Now, that's going to be your second discussion post for this week, for this module. So you'll find this lecture very helpful as well. So I'll talk about each one of those three cases. I'm just going to ask you to talk about one of those cases and share your opinion, whether you thought that case was correctly decided or not. One of the things I want to let you know is that law can sometimes be very controversial, very contested is the word professors like to use. Sometimes there can be competing visions of what the law is or what the law should be. And so I just want to set that out at the beginning. But actually what I want to do, I want to get started by talking about a great legal historian, an English legal historian, an Englishman, F.W. Maitland. F.W. Maitland once described the common law and the law generally as a seamless web. And to this day, I consider that to be the most beautiful and haunting, and I think accurate description of what the law is. What is a web? And here I want to invite you to think of a spider's web. A spider web, right, is like literally has it's made up of the silk of the spider, and it has all of these interconnected parts, right? One part is ultimately connected to another part via the web. And that's what the law is. I like looking at the law as an interconnected or seamless web because the law has a lot of different aspects to it, all the way from international law and customs, customary law and treaties, all the way to state and local law. And in between the United States, we're going to see we're a federal system and we have something called federal law. So let's just jump in and look at these three major sources of law. And then along the way, what I'll do is I'll talk about these three important cases. And those of you who are attending live, feel free if you want to jump in if you have a question. I'm not sure if I have a teaching assistant available today to moderate the chat. So what I'll do at the end, I'll be sure to I'll take a peek at the chat and let you know about that. I answer your questions via the chat. I'm sorry if you prefer that. Let's start with state and local law. The main thing is I need to back up and let everybody know when we talk about the legal environment of business. We'll say more about ethics later on. But when we talk about purely the legal, like when we talk about ethics, right? Ethics is ethics, right? It doesn't matter whether you're in the People's Republic of China or in the United States, right? You would think, now right and wrong may have a cultural dimension, but generally speaking, ethical rules are supposed to be universal, right? And maybe even transcend time and place, even if they maybe do vary over time. Law, though, is very, very dependent on the time and place. Law is very much geographical and territorial based, at least traditionally. Maybe in the future, things will change as we move into a metaverse, that kind of thing. But here's the deal. The United States, the U.S., it is what we call federal system. What that means is it's a fancy way of saying that we have two levels of government and two levels of law in the United States. We have federal law emanating, from Washington, D.C., beginning with the Congress, the Capitol legislation, et cetera. the Supreme Court in Washington, D.C., and the lower federal courts across the nation, the executive branch, the president issuing executive orders and commanding this enormous, massive structure of all these government agencies, federal government agencies. But at the same time, the United States is composed of 50 sovereign states. And these states are also a separate source of law. And in fact, unlike the federal government, and this is the important thing you need to know about our legal environment, unlike the Congress, unlike the federal government, whose powers are enumerated and delegated by the Constitution. In fact, James Madison himself famously said, I believe it was in Federalist Paper number 45, that the powers of the federal government are, quote unquote, few and well defined. Only those powers that are given to the federal government by the Constitution, are federal powers. The states, however, including Florida and the other 49 states, the states have vast panoply of police powers. The police power is perhaps the single most important power because it's the power to regulate. As long as you don't violate the Constitution, as long as you don't infringe on people's individual rights, and usually it's the courts that will determine what those rights are and how they're enforced. But the states have a general police power to protect the health, safety, and welfare of the public, whereas Congress only has those powers that are given to it by the Constitution. So a good example of this, and this is why I use Tiger King as a theme, because look, we have 50 states, and all of the 50 states have enacted a whole bunch of laws. The Congress at the federal level has enacted a whole bunch of laws. If you've checked out my blog posts, you'll notice that back in the 1920s, all the federal legislation could fit in a single volume, a single book of the United States Code. Today, in 2022, almost 100 years later, the United States Code is comprised of right now it's 51 volumes that are pretty thick, 51 volumes of federal laws, plus literally 1,000 times bigger code of federal regulations. So the federal sphere has really expanded, to match the state sphere. Now, here's the key thing: how can it be? How did the federal government get so powerful? Why do we have so many federal laws when the powers of the Congress are those that are, specifically delegated or enumerated or spelled out by Article 1 of the Constitution? Whereas the states, by contrast, have a general police power to pass any law as long as it's designed to protect the health, safety, and welfare of the public, and as long as the law doesn't, infringe on your fundamental rights. So here's the deal. One of the powers given to Congress by Article 1, Section 8 of the Constitution is the power to regulate commerce, is the power specifically to regulate interstate and foreign commerce, and also commerce with the recognized Indian tribes, and so in our country. And so if you think about it, the legal environment of business, right, everything that we do, everything that we touch is, is a product made by a business. So Congress, probably, I would argue, its most important power of all the powers, including the power to declare war, which has only been used 5 or 6 times in our nation's history, including the power to create a post office, including the power to, regulate the militia. Congress's most important power is the power to regulate commerce, because almost every activity we do is somehow affected to commerce, either directly or indirectly. And so that's going to give Congress a jurisdictional hook to exercise its power to legislate or regulate. Now, so that's how the federal government has grown. But let's focus on the states first, state and local governments. By the way, all local governments like Orange County in Florida, or maybe you live in Pinellas County, or I know some of you are in Broward County. Shout out to Duval County, all the great counties in the state of Florida. There's Collier County and Naples, etc. All the counties get their power from the state legislature, from the state constitution. So when I talk about state power, I'm also talking about local power. State and local power, this general police power. A great example of this is the law, Florida's animal cruelty law, that is I've included in Module A. So Florida, as part of, and all the other states, by the way, as well, as part of their police power to protect the health, safety, and welfare of the public, they have decided we're also going to protect animals, and we're going to make it illegal. We're going to make it a crime to harm animals. And so that's something that, nobody is going to disagree with, right? But it's kind of interesting. If a state has the power to protect, health, safety, and welfare of people, does that include the power to protect the health, safety, and welfare of animals? It's actually kind of an interesting question, right? Non-human animals, as biologists might say. What about Congress? I've also included in Module A at the in 2019, November 2019, Congress enacted a federal statute to also protect against animal cruelty. To me, that is much more dubious. I'm something of I'll put my cards on the table. I'm a conservative jurist. So I want to keep the powers of Congress in check. I am distrustful of government power, generally speaking. And to me, I don't know how protecting against animal cruelty, not that I'm for animal cruelty. On the contrary, animal cruelty should be punished, and it should be punished vigorously, But does Congress really have the power to protect animals, right, against animal cruelty? That's not in the Constitution. What does that have to do with commerce, right? And so what Congress did when it enacted the Federal Animal Cruelty Protection Act, it basically said that it tried to say, in the opinion of Congress, we think that the mistreatment of animals, because animals are used in commerce, animals are used in TV productions, animals are used in medical research, animals are domestic pets that are bought and sold. So because animals are articles of commerce, we have the power to regulate how animals are treated, and we can make it a federal crime for you to mistreat an animal. So, to me, that statute is probably going to be challenged in court in the near future. If anybody is ever prosecuted under the Federal Animal Cruelty Act, notice, right? If the Department of Justice of the federal government doesn't prosecute anybody under the Federal Animal Cruelty Act, that doesn't become an issue, right? But my prediction is, if I'm a lawyer and my client is accused of committing federal animal cruelty, I'm going to challenge the constitutionality of that law. Now, I might lose. The court might agree with the government that animals are articles of commerce, and therefore that's going to give Congress the power to, protect animals under the against animal cruelty. Now, at the state level, there's no controversy. States can actually regulate and protect the health, safety, and welfare of the public. There's something of a controversy. Are animals, part of the public? But generally, that police power is interpreted very broadly. In fact, courts use what's called a rational relation test or rational basis test. As long as the state law has some connection, some reasonable connection to the objects it's designed to promote, in this case, the protection of animals, then that law will be constitutional. Here is the Wilkerson case, Wilkerson v. Florida. To me, even though it looks like a very simple case under the Florida Animal Cruelty Statute, it actually turns out to be one of the most important cases that the Florida Supreme Court has decided. Here are the facts. You have Mr. Wilkerson, who this case actually originates in Osceola County. And, maybe some of you have heard of bears coming out, and, rummaging through people's trash and causing some damage. Well, what was going on in this guy's backyard is that, he had some trash cans and there's some wild raccoons, wild animals coming in and foraging. And what this guy did is he took his shotgun and he killed the wild animals. He killed the raccoons that were, going through his trash, shot them, with a shotgun. And so the state attorney brought criminal charges against Mr. Wilkerson for violating, the animal cruelty statute, By the way, quick timeout. What about chickens? How come the CEO of Chick-fil-A is not being prosecuted under the animal, or the CEO of McDonald's, or whatever your favorite fast food place is, Chipotle, right? How come they're not being prosecuted under the animal cruelty statute of Florida, right? Why do raccoons get special protections and not chickens and, the beef, the cattle, from which the beef is for the hamburgers, right? That's exactly the argument that Wilkerson made, that Wilkerson's lawyer made. Because here's the thing. Wilkerson was guilty. He was guilty, yes and right. He did kill those wild raccoons. He had no defense here, right? He did do what he was accused of doing. So what did his lawyer do is, I'm not going to lie. I'm not going to deny the facts. I have to be honest. I'm an officer of the court. The lawyer, this is why you need a lawyer if you're ever accused of misconduct, whether it's the Student Conduct Committee at UCF or like a serious crime, by the state, or a federal prosecution, like we'll see the Yates case later on. His lawyer said, okay, I can't deny the facts. This did happen. There isn't, but what I'm going to do then is I'm going to challenge the law, and I'm going to argue the law is illegal. The law is unconstitutional. And this is the question one. If you decide for the first option, he made the argument that the Florida statute was void for vagueness. This is called the vagueness doctrine. And this, even though this doctrine only applies to criminal laws and criminal statutes, I would submit to the class that the void for vagueness doctrine is one of the most important legal doctrines in our constitutional system. Why? For two reasons. It applies both to Congress and to the states and local governments. And for example, you may have heard a lot of especially like in South Florida, a lot of municipalities and cities have enacted like noise ordinances where it makes it like a misdemeanor to play your radio, your boombox, or your car system, your stereo, excessively. Almost all of those statutes have been declared unconstitutional or illegal under the void for vagueness doctrine, because what's an unreasonable noise? You know what I mean? So the few statutes that have passed muster will define the decibel level. And there it's going to have some rational connection. There's going to be some scientific evidence that, yeah, this is beyond. I remember, I'll never forget, I'll share you a personal story. I'm a huge Yo Gotti fan. And so my wife and I got to see Yo Gotti in concert like a few years ago. He was here in Orlando at a small club. And I made the mistake of standing by the speakers. I could be up front. And let me tell you, I think I have, I still have some loss of hearing from that night. But so, there's something to that, right? But you just can't say you can't make an unreasonable noise, because that gives the government too much discretion. What's an unreasonable noise? You know what I mean? I'm Latin, I have a pretty big mouth, I'm loud, so it's like, could I be prosecuted for making an unreasonable noise just for speaking? No, the law has to define specifically what is too loud, to constitute a criminal or civil offense. So that's exactly what's at play here. If you look at the definition of animal and the Florida animal cruelty statute, and don't get me wrong, I'm not some kind of animal rights, activist or anything like that, although I think we should think about, the rights of animals. And, but you look at the way the animal is defined, the Florida animal cruelty statute says that an animal is, quote unquote, any dumb living creature, And the thing about it is, Wilkerson's lawyer was making the point, well, does that include a raccoon? Does that include a goldfish? Does that include, I would argue a chicken, if I'm why isn't Chick-fil-A being prosecuted? Like all animals, what do we mean by dumb? All animals are intelligent, all animals have, this is something called the study of ethnology. In fact, one of my favorite textbooks of all time, I happen to have it right here. It's in the middle of my bookshelf. It's Robert Trivers' book on social evolution, where he describes how animal behavior has evolved over, long periods of time. That not just our genetic composition evolves over time, but our behavioral strategies can evolve over time. This is called evolutionary game theory, an area that I do in my research when I'm not teaching. So anyways, I personally think that Wilkerson had a great argument. I thought Wilkerson should have won. I thought that just like, if you don't define what an unreasonable noise is, you cannot prosecute me for, making a loud noise. You just can't define animal in such a crude and terrible way. What's interesting here, though, is sadly for Wilkerson, he lost the case. The Florida Supreme Court said, no, you know what? This definition is sufficiently precise that it does include, obviously, a raccoon, And I'm not saying that's a wrong decision, because, yeah, you could say common sense, the word dumb maybe is not meant in the literal sense. What we have to focus on any living creature that's non-human, But then cockroaches, right? I hate mosquitoes, right? Every time I swat a mosquito, right? Why am I not being prosecuted? So I think Wilkerson had a good point. I also wonder whether if that case were brought today, whether Wilkerson would lose. That today, that case was decided in 1980. Right? Today is 2022. We have a much more, appreciation of animals and animal rights. So maybe the case would come out differently. That's what I mean. That the law is a function of time and space. The geography, who has the right to enact the law and enforce the law. In this case, the states have a general police power to protect health, safety, and welfare. So, in this case, they decided to use that power to protect animals. And in this case, the Florida Supreme Court said that the definition of animal as any dumb living creature that is sufficiently precise or not vague, to not run afoul of the void for vagueness doctrine. But I include that case because to me, I think it's wrong. I'm going to be honest. I think it's wrong. I think I think it should even be that a court should consider even overruling it, and requiring the Florida legislature to come up with a better definition of animal. Because does that include insects? Does that include, does that include chickens that are used for fast food or for processing eggs, etc.? I think we need a better definition. All right, that's state law. The bottom line takeaway here is two things: that the states have a general police power, and the police power includes the power to enact any law to protect health, safety, and welfare. The only way that a law such as that would be declared unconstitutional if the law were vague, if it were a criminal statute, if the law did not precisely define what type of behavior constitutes the crime. And that gets to my second point. That is what we mean by rule of law. That's why the Wilkerson case, whether it was correctly decided or incorrectly decided, that's why the Wilkerson case and the vagueness doctrine is so important. Because what we mean by rule of law is that the government has to obey its own laws, and that the government cannot abuse its powers, whether, for whatever purpose. And so that's why the vagueness doctrine was developed by judges and common law courts in order to, both in England and the United States, in order to judicially limit or circumscribe the exercise of arbitrary government power. So that vagueness doctrine is really important, regardless of the outcome of the Wilkerson case, very important doctrine, because it's telling us that before you can be punished for a crime, that crime has to be sufficiently well defined that any reasonable person, would understand what is illegal and what is legal. To me, that is very important, because I really wonder whether we still live in that world. There's so many laws, and so many of these laws are vague and complicated. I wonder how many laws could really pass the vagueness test if courts were to really exercise their authority in a more vigorous fashion. I just want to throw that out there. But it's an important doctrine, and it's always out there, designed to limit government power, even the state police power that the states have. Okay, now that's state law, right? And by the way, I always start with state law is because before we had a constitution, before we had a United States, we had something called the Articles of Confederation, and we had 12 member states. Rhode Island was never a member of the Articles of Confederation. So they, it's 12, not 13. Yeah, there were 13 colonies, but there were 12, members of the Confederation in 1778, up until the adoption of the Constitution in 1778. So our system begins with the state and local governments, Then when the new Constitution was drafted in Philadelphia in 1787, and then the Hamilton and Madison and John Jay wrote the Federalist Papers, and the Constitution was ratified, by 9 of the 13 states, eventually by all of the states. I think Rhode Island was last, Delaware was first. But once what the Constitution does, it creates a new government. It creates the federal government that's now located in Washington, D.C. Before it was in New York City, then Philadelphia. Now it's, Washington, D.C. is the seat of the federal government. Now, here's the deal about the Constitution. It's a compromise. Basically, the compromise was that, and this is what the Federalist Papers try to explain. Hey, those of you who are anti-federalist, those of you who distrust the government, those of you who are, wary of Washington, D.C., what we today is Washington, D.C., here's a compromise. We're going to limit federal government power in this Constitution by only giving it specific, narrow, delegated, enumerated powers. Now, like I said earlier, one of those powers is the power to regulate commerce. So Congress enacted back in the 1970s something called the Endangered Species Act. And if you watch Tiger King, either season 2 or even back to season 1, you'll see that the Endangered Species Act is a really, and then as it was further amended by something called the Lacey Act. Now, you don't need to know that for this class, but just know that the Endangered Species Act, right, is a good example of federal law. Now, what do endangered species have to do with commerce, right? How is it that Congress, I understand that the states have the power maybe to protect endangered species because they have a general police power. And if that includes, prevention of animal cruelty, the states could, if they wanted to, protect endangered species. But the theory of the federal government, as put forth by Hamilton and Madison in the Federalist Papers, is that sometimes when you have a problem that affects the entire country, you want Congress to deal with that problem. So you have a single solution for the entire country. And so the idea here is that endangered species, like you saw in Tiger King, like lions and tigers, people, unless the Big Cat Public Safety Act becomes law, you can buy and sell a big cat, right? You are in those states where it's legal, right? Some states like California have used their police powers to make it illegal to buy or sell or ban a big cat. You know what I mean? If the Big Cat Public Safety Act, if Carol Baskin gets her way, that would become illegal nationwide, under federal law. And so the Endangered Species Act, like the Big Cat Public Safety Act, are considered, exercises of Congress's power to regulate commerce. Personally, like I say, I'm a more conservative jurist. I don't know if really this is really about commerce at all. I don't know if Congress, I would be skeptical. I think Congress has gone too far here. If the states want to protect endangered species, be my guest. But the courts have, they've already ruled, the Supreme Court already ruled the Endangered Species Act is, within Congress's power to regulate commerce. Now, here's an interesting question, though, and I assigned the Lujan versus Defenders of Wildlife case. This is, to me, the single most important case that we're going to study, I would argue, all semester. We're going to study some important cases, some leading cases in business law and leading problems in business ethics. But what makes the Lujan versus Defenders of Wildlife case so important, where I would go onto a limb and say it's even more important than the rule of law case in Wilkerson that we talked about under state law, is because Lujan poses the most fundamental question of all. Can you sue the government when the government fails to comply with its own laws? What's really interesting, one of the things you see in Tiger King, like in season 2, is when they go after Jeff Lowe and Tim Starks, when the feds go after those individuals, those private roadside zoo owners, one of the things that they're going after them is under the Endangered Species Act. What the Endangered Species Act does is it doesn't say you can't own, exotic animals. But what it does say is that if you own an animal that is on the endangered species list that is maintained by the Department of Fish and Wildlife, then guess what? You have to submit some paperwork to the government about where you bought that, exotic animal, where you got it from, how much you paid, what's the age of the animal. And, if you ever sell the animal or if the animal dies, you also have to fill out some paperwork. So what happens is if you put a lie on that paperwork that's required by the Endangered Species Act, then yeah, you would be committing a federal crime. So I understand, like if Joe Exotic, in addition to murder for hire, if he broke the Endangered Species Act, if Jeff Lowe, I understand that they should be punished for that, right? But what happens when the government doesn't comply with the Endangered Species Act? So this is the Lujan case. It's a really interesting case. Back then, the government, I think the case originated when President H.W. Bush was president, W. Bush's father. When he was president, basically the United States Assistant International Development Office, USAID, they released a lot of money in Egypt for Egypt to build this what's called the Anwar Dam. And it's actually, I actually had the honor of visiting the Anwar Dam many years ago, and you have to go under a police escort because it's close to the Ethiopian border. And back then, even today, there was a civil war, and so you go under military escort. And anyways, the thing about the Anwar Dam is that it would have negatively affected the Nile crocodile, which is an endangered species under the U.S. Department and Fish and Wildlife's Department endangered species list. So Defenders of Wildlife and the Sierra Club and other groups, they sued Lujan. Who was Lujan? Lujan was the Secretary of the Interior and who authorized this U.S. aid package to Egypt. Also, there was some money dispersed to Sri Lanka, and this the spotted white tiger, which is another rare, beautiful animal, was also going to be endangered by this development project that was authorized, like a hydroelectric plant for Sri Lanka. So Defenders of Wildlife decided to sue the government. Hey, you're not even complying with your own laws, because those laws say that you cannot give any money to a project if that project is going to endanger an endangered species, if it's going to adversely or negatively affect the habitat, of an endangered species. And both the Anwar project in Egypt and the hydroelectric project in Sri Lanka would have affected the Nile crocodile and the spotted, the white tiger in Sri Lanka, respectively. So the defender was said, hey, how come the government is doing this? They have to comply with their own laws. And so that's why that's an important case. And this case goes all the way up to the Supreme Court, as you can imagine, because it's a really important case. Think about it, right? Think about it. What do you do when the government refuses to comply with its own laws? You may not like the Endangered Species Act. You may not care about the Nile crocodile, but if there's a law that says, you cannot, do X, Y, or Z to harm an endangered species, and the government is giving money to a project that would endanger two endangered species, that's a violation of the law. And so they're in a very leading case. This case was decided while I was still in law school, by the way. So I remember, it was a very important case, and it's still a leading case. There, the Supreme Court reaffirmed something called the doctrine of standing, or standing doctrine. And that doctrine, it's very controversial. It says, in order to sue the government, just because the government is not complying with its own laws, sorry, that doesn't mean you get to sue the government. If you want to sue the government for not complying with its own laws, you have to establish standing. And standing has three elements to it. First, you have to establish that you yourself suffered an injury by the government's non-compliance with the law. Secondly, you have to show that the injury that you suffered is a direct result. There's a nexus or a causal connection from the government's non-compliance with the law. And lastly, you have to show that the injury that you allege is quote unquote judicially redressable. That is to say that the courts are in a position to provide you a legal remedy. Now, what's really, to me, unfair about the standing doctrine, it sounds like common sense. You have to suffer an injury. The injury has to be caused by the government. And, the courts have to be able to provide you a remedy that's adequate. But, this is why you always need a lawyer. You always need to consult. In reality, what the Supreme Court is doing there, it's creating an asymmetry, right? Because if you want to sue the government, you have to prove all three of those elements, of standing doctrine. If you're the government, right, and you want to get the lawsuit dismissed, all you have to do is attack any one of those three elements. And if you persuade the court that you're right, the case gets dismissed. So there's a built-in asymmetry in the standing doctrine, which I personally think is unfair. Because after all, we're talking about the government trying to comply with its own laws. If anything, the court should be making it easy for me to sue the government when I allege that the government is not obeying its own laws. I mean, that to me is fundamental. But I will tell you, the standing doctrine, though it was a 5-4 case, is now enshrined in our constitutional, doctrine. So you have to show standing. In the Lujan case, the Supreme Court decided 5-4 that the defenders of wildlife did not have standing, that they did not have a sufficient concrete injury, even if it was true that the Nile crocodile, was going to be harmed or even, become extinct, because of the Anwar Dam project, And so to me, this is a controversial case because the defenders of wildlife, think about who is environmentalists, right? Usually it's rich people are environmentalists, right? People who drive Volvos and have, a lot of disposable money to go to Whole Foods, et cetera, So the defenders of wildlife, they actually had evidence that they had members of their association that had traveled to Egypt in the past to see the Nile crocodile, that they were willing to spend thousands of dollars to go all the way to Egypt to see this beautiful, majestic animal, and that they were going to go in the future. So to me, that's kind of an injury, if, you know what I mean? If you're willing to spend money and then, you may not be able to see the crocodile ever again, So it's like, personally, between you and me, I think the court didn't believe that, I think they just didn't believe that the defenders of wildlife would really spend all this money to see the crocodile, But, I think today, again, in this case, we're 2022, people do spend a lot of money on these amenities, to see a rare, bird if you're bird watching, or, to see the Nile crocodile. I think, that is possibly what could be going on. But that is the Lujan versus Defenders of Wildlife. It's an important case involving the Endangered Species Act. You don't need to know for this class about the Endangered Species. I'm not going to test you on that or ask you about that. But you do need to know about the standing doctrine. When can you sue the government when you're alleging the government is not complying with its own laws? And I would say, unfortunately, is my opinion, it's actually very difficult to sue the government because you, the plaintiff, you, the person suing the government, have to establish standing. You have to establish that you were injured from the government's failure to obey the law and that the court has the power to provide a remedy. By the way, that last point is very important because think about it, right? The courts do not have the power of the sword, to borrow Hamilton's phrase in Federalist number 68. That is to say, the courts don't have any, the courts can't really order the president. President is the commander in chief. He has the army at his disposal, right? If the court were to try to order the president, hey, you have to stop giving money to Egypt to build the dam, the president is just going to ignore the court if that's what he wants to do. You know what I mean? And so that's a very delicate, the judicial redressability. But I would argue, to me, the injury is the government is not complying with its own laws. Why do I have to prove an additional injury? That's why, personally, I'll just let you know, as a scholar, I don't like the court's decision. Now that I should say that this is a rare disagreement between me and Justice Scalia, Antonin Scalia, who authored the majority opinion. I had the honor of meeting Justice Scalia a couple of times, along with Justice Ruth Bader Ginsburg one time. And I'm a big fan of Justice Ginsburg. Justice Ginsburg, and especially Justice Scalia, his textual approach to the Constitution. But because standing is not in the Constitution, I felt that Scalia was wrong in that particular case. But that is the law of the land. Finally, we have international law. That is the last source of law. Now, what I have done in the module is I've included an example of something called the International Convention for the Protection of Animals, the ICPA. And what that law would do is basically the Big Cat Public Safety Act, but international. It would make it illegal to buy and sell big cats and other exotic animals in addition to big cats, across international borders. Here's the thing about the International Convention for the Protection of Animals. That treaty has not been, voted on by the Senate. So that treaty, even though other countries have adopted it, the United States hasn't adopted it at all. So it's not part of our law. That's one of the most interesting and unique aspects of international law. Normally when you think of law, right, it's something that you have to comply with or run the risk of maybe negative consequences if you get caught, right, and prosecuted. In the case of the Animal Protection Treaty, because it hasn't been ratified by the U.S. Senate, it's not part of our domestic law. That doesn't mean that our United States is not committed to animal welfare. For example, one of the most important treaties involving animals that the United States does belong to, that the Senate did ratify, and that we are a member of, is the Whaling Convention, the International Whaling Convention, or the Whale Treaty. So back in 1948, I believe it was, in order to protect, whales are the largest mammals on Earth. They are magnificent and super intelligent creatures. You know what I mean? The United States and a host of other countries joined the International Whaling Convention, and so that treaty became part of our law. Now, what's interesting is the treaty has been criticized because the treaty has two important exceptions. One for scientific research. You're allowed to hunt a whale if it's related to scientific research. And also, there's also an exception for native tribes or indigenous peoples. So if you can prove, to the International Whaling Commission, which is located in Washington, D.C., by the way, that you're a member of an Indian tribe or a Native, American tribe, or, Canada is also a member of the Whaling Convention. If you're one of the first peoples of Canada and you have a custom or a tradition of hunting whales, they'll also make an exception for you there as well. And so it's been accused that countries like Norway and Japan have abused that exception, for the scientific research side. So, that's the controversy right now with the Whaling Convention. But I want to let you know, right, that's really interesting about treaties, right? Treaties did not become part of American law unless and until the Senate ratifies. By the way, the Constitution requires a 2/3 majority, 60. So you think the filibuster is hardcore with 60. For a Senate to be for a treaty to be ratified, you need 66 senators, really 67, right? 66 plus 1, in order, assuming you have a quorum of 100, right? In order to get the treaty ratified. But once the treaty does become ratified by the Senate and the Congress as a whole enacts what's called enabling legislation, telling the courts how to enforce the treaty, then the treaty becomes part of our domestic law, like it were any other, state or federal statute. So that's an important point to keep in mind, that with treaties, there's a sort of an election procedure, right? Treaties are not part of our law until the Senate acts, and then it becomes part of our. It will become part of our domestic law. What's really interesting, by the way, with those treaties that have been ratified, what happens when you have an international treaty that's ratified by the United States Senate that has principles that are inconsistent with our domestic law? That's a really tough question, but I'll give you one important example. There's something called the Budapest Convention of 2002. It's another treaty that the United States has joined, has ratified. I believe it was in 2008. The Budapest Convention has to do with international hacking, computer crimes. And one of the computer crimes, according to the Budapest Convention, is disseminating hate speech. So if you disseminate hate speech, bigotry, racism online, that can be considered an international crime under the Budapest Convention. However, under existing US constitutional cases by the United States Supreme Court, There's this case, you don't need to know it for this class, but in con law, if you go to law school, you'll need to know the Brandenburg versus Ohio case. That case says that hate speech is protected speech, unless it's accompanied by imminent threats of violence. But hate speech is protected speech and cannot be punished or criminalized by the government. Now, if Facebook wants to ban hate speech on their content moderation policies, Facebook's a private company. And so far, pretty much the courts have given Facebook a free hand to play. You know what I mean? And will the Supreme Court? I personally predict the Supreme Court will overrule Brandenburg versus Ohio in the future. You know what I mean? But as of today, January 2022, hate speech is technically protected speech under the First Amendment. That the government cannot criminalize. Private companies can do whatever they want. They can they can put sanctions on their employees and user base, and they can define hate however they want. But governments are not allowed to regulate hate speech unless it's accompanied by threats of imminent violence. So, that's an interesting problem that the Budapest Convention will probably have to get resolved eventually in the courts. If it ever comes to that. All right. So we've seen. We're almost done. We've seen examples of state, federal, and international law. State law. We saw the Animal Cruelty Act, and we saw the Wilkerson case, right, in their Florida animal cruelty law.
Professor.
Yes, jump in, please.
I had a question. I'm just because I'm going to probably end up talking about the Wilkerson versus Florida, but I was thinking, so he basically pleaded guilty for killing a raccoon, but what about people who hunt?
Oh, excellent point. Yeah, exactly right. And that's kind of interesting, right? The statute, if you go, and by the way, great question. Thank you for bringing that up. It's in the spirit of, what about Chick-fil-A? What about fast food, right? They kill a bunch of animals. How come they're not being thrown in jail? Like poor Mr. Wilkerson, right? So here's the thing about hunting. That statute, and I'll answer my question about, fast food, and I'll answer your question about hunting. That law, in fact, if you go into the module and you pull it up, it's actually a very long law. I only focus on the definition of animal, which I think is a pretty bad definition, But if you look at that statute, there are so many exceptions. So there's an exception for cattle ranchers, right? So it's okay to kill cattle as long as that's part of your business, right? There's going to be an exception for, that's the Chick-fil-A exception, if you will, the McDonald's exception, right? So if your business is to grow animals, to slaughter, to sell them, that's fine, because that's. Now you could say that's common sense, right? Because there's a big market in fast food and food generally. But again, if we're about here protecting animals, that seems to me kind of inconsistent, right? And then to your question, which is a really, really good one, there's also exceptions for hunting, right? So this is where the Florida Department of Wildlife, right? They that power is delegated to them. They decide, when to authorize hunting licenses and how, under what conditions. So there are exceptions in that law. And what's really interesting, this is Hamilton's argument for federal law, right? So each of the 50 states, right, will have their own animal cruelty law. Each of the 50 states will define animals a little bit differently, and each of the 50 states will have different exceptions, right? For different types of animals and different types of businesses that use animals. So this is one of the great things of federalism, or one of the most terrible things of federalism. So, so that's what's going on in there. If you do read the rest of the statute, there are all of these exceptions. But my point is, so why does poor Wilkerson, get, okay, I understand there's an exception for hunting, right? As long as you have the license and you're following the Florida wildlife regulations, right? I understand the exception for Chick-fil-A and McDonald's and Wendy's, right? Because that's their business to, slaughter animals to provide for the public. That's fine. That's, people, that's a legal business. But I still feel bad for poor Mr. Wilkerson, who's just trying to protect his yard from these wild raccoons that are just throwing the trash everywhere. You know what I mean? Not to say that those animals don't deserve protection, but it is interesting how the statute, so in lawyers, we call that, it's under inclusive, it only protects some animals, but not all, and so is that really rational, even under the police power? Forget about it being vague or not. So in law school, those are the things you're going to learn, but that law does have exceptions. And because the states do have a general police power, they can make any exceptions they want as long as the exceptions are reasonable or have a rational basis. So fast food industries, because that's perfectly legal, that makes perfectly good sense to have, it's perfectly reasonable to have an exception for fast food and businesses that, kill animals to sell it for food. Hunting, because there's a big tradition of hunting, and hunting, hunting is a big, generally it's legal as long as you follow the rules. Exception for hunting. So courts have said that's always going to be rational. That's always going to pass the rational basis test. Now, the last, but that's a very good question. Very good question. That does beg the question, right? If we really cared about the protection of animals, right? Why do we have exceptions for hunting? Why do we have exceptions for fast food and food, businesses that kill animals for food generally, right? So, so. And this is an important point. I don't mean to criticize the law, because people have to eat and people need protein, people need nourishment, right? And, my family is, Cuba, and I lived in Puerto Rico many years. So I love lechon asado. That's roast pork. You know what I mean? It's a big tradition, Noche Buena, Christmas Eve. So yeah, I have to admit, I love that, so it's like, we're not going to just ban that overnight. You know what I mean? And so the law is always trying to make these compromises to, okay, we want to protect animals, right? We definitely, nobody hears about, abusing animals, but at the same time, we want to make reasonable exceptions for our, traditions and things like that. Now, what this class is about is, should we rethink our traditions? Should we maybe be more solicitous of how we, slaughter our animals and whether we eat animals at all? Again, I'm someone who eats meat. I just want to be a good professor and throw it out there that at least we should think about it, to be good people, good citizens, how should we treat animals? And is the Florida animal cruelty statute, is it too little protection, or is it too much protection? Maybe people should be free to kill wild animals if those animals are destroying their property or destroying their, their trash, and that kind of stuff. Maybe there should be an exception for protecting your property as well. So I just want to be fair and show both sides of the argument, that just because something is a law doesn't mean it's, has to be right or can't be changed in the future.
Right. Yeah.
All right. Yes, jump in.
I just want to ask one more thing. So did the vagueness doctrine come after the Wilkerson case, or was that already a thing before?
Oh, great question. Yeah. Excellent question, because I didn't make that clear, since I'm just kind of like parachuting and using animal cases to illustrate, these big principles of law. But no, the vagueness doctrine goes back. We'll see this when I talk about the common law in module B next week, and the week after for the optional Zoom, and then the in-person next week, if you want to come. The common law. So this comes from basically centuries from, English cases. Same thing with the standing doctrine is of more recent vintage. Lujan is an important case because it sets the outer limits of standing, but standing doctrine goes back to at least the 1960s, from the Supreme Court. So these are all doctrines that have existed before. I've chosen these cases just because they involve animals, so they're consistent with the Tiger King theme. Lujan, though, is actually studied in law schools all across the country to this day. That's an important case, whether you care about animals or not, whether you care about the Nile crocodile or not. So what Wilkerson does is it tells us, okay, we have this void for vagueness doctrine that goes back centuries, but now it's applying it to a new situation, right? A new animal cruelty statute, or relatively new compared to the centuries of the common law, and we're gonna, so that's what courts are gonna. In fact, that's my next section, because if Professor Maitland, from the 1800s, if he is correct to say that the law is a seamless web, that the law is kind of like a spider web, interconnected. The way I look at the law, I put state and local law right in the middle. That's where the law originates, right? In our local jurisdictions. Mm-hmm. You might even go further into the family, like Aristotle, but we won't go that hardcore. Then I look at what I call the federal law is always expanding, all these new laws and regulations at the federal level being enacted every day. I call that the expanding web. And then finally, I look at international law, because it's up to each country to decide whether to ratify a proposed convention or a treaty. I call that the outer edges of the web. But who are the little spiders, right? I like to call it law's little spiders, right? Who are the spiders creating the web, shaping the web, modifying the web, right? And though, to me, is judges, right? Judges play a really important role in the US legal environment and in most other places too, but especially in the US legal environment. Why? Because of the problem, what I call the problem of legal interpretation. A law, no matter how clear, right, is going to have ambiguities, is going to have exceptions. Like the most famous example that I learned in law school was actually a local ordinance. It said no motor vehicles in the park. And actually, if you go to, I forgot the name of that park now. There's a YMCA by the university where there's a beautiful river. I forgot the name, I forgot the name of that park. The soccer field. And there's actually a little sign that says no motor vehicles in the park. And one day I like to go there. That river is so beautiful. One day I'm just, going there, hanging out, checking out the river, meditating, and then reading my books. And then I walk back to my car, see a sign, no motor vehicles in the park. And what do I see? I see a golf cart, with the Orange County picking up the trash, on the nature trail. But the sign says no motor vehicles in the park, right? How is it that this is not some private citizen? This is the government that put the sign that says no motor vehicles in the park, and that would make it a fine for me to drive my vehicle, my car or golf cart or whatever, motorized moped on the nature trail, right? They can go ahead and, drive their vehicle when it says not to. And so the idea there is, of course, if it's a trash pickup and is a golf cart really a vehicle, maybe the law means, automobile. But what about an ambulance? What if there's an emergency, right? What if you have a kid with a remote control airplane? That's technically a vehicle, right? Are they not allowed to play with that in the park, right? So you could even a simple ordinance like no motor vehicles in the park. It can create a number of ambiguities. So the last case I assigned, and the last case, if you remember, you just pick one of the three cases. I'm not going to make you do all three. It's not law school. This is more a survey. You pick the case you like. Wilkerson is a great case because the vagueness doctrine is so important, But the Yates case is very important because it involves a fundamental problem, the problem of legal interpretation. In fact, all of the cases ultimately that go up to the Supreme Court involve some issue of interpretation. And so judges play a really, really important role in determining, like, when is something within the police power? When is something have a rational connection, to fall within the police power? When is the protection of animals related to commerce? Judges have to make those interpretations when the law gets challenged in court. So Yates is a great case because it also involves wildlife. It involves fish. It involves a red grouper. So Captain Yates, who operated out of Tampa, Florida, he was with his crew fishing a red grouper. And what happened was there's a U.S. Department of Fish and Wildlife did like an unannounced inspection. And they saw that a lot of the grouper that was in Captain Yates's catch was undersized. It was caught in violation of federal and even state laws. And so the thing about it was that, if you catch undersized fish, a federal law and state law, depending which applies, will force you to throw it back. It has to be of a certain size. And the idea is, you want to keep the population stable, so smaller fish are probably juveniles. And so keep them in the water so they can mate and create more fish. Bigger fish are probably older, right? So if you catch them, we're going to let you keep it, and then the regulatory agency will decide, based on scientific evidence, what is the size, the catch size, So here's what happened though. This is really what I love about this case is that Yates said, basically, big middle finger to the government, big middle finger. You know what Yates did? He instructed his crew to just throw all the fish overboard. The theory being that, they were still alive and flapping. Those fish are going to swim away. If there's no evidence, the government is not going to be able to, bring any criminal charges against me or impose any penalties. Like Captain Yates, if I could let me pretend that I'm his lawyer. Captain Yates was really upset. How dare the government come in and interfere with my business operations here? I'm just trying to make a living, Yeah, maybe my fish is a little bit small, but come on, man. You know what I mean? I can't keep tabs on all my fish. I have, hundreds, if not thousands in my fish in my catch. And so the government, of course, their position is that, no, we have to enforce these laws because if you catch too many small fish, they're not going to be fish to catch in the future, right? That's the problem of overfishing. So what ended up happening is the government said, oh, we're not going to let you get away with this. You think you're slick. You think you threw the fish overboard, and so we can't bring a case against you. Well, here's what we're going to do. We're going to charge you with the destruction of a financial record or other tangible object. So those of you who are accounting or finance majors, perhaps the most important law out there, it's not going to be the Endangered Species Act, right? Unless you're going to run a zoo or something like that, a private zoo. It's going to be the Sarbanes-Oxley Act of 2002. What that law says is it makes it a federal crime to falsify financial records of your business. It makes it a federal crime. And you have to understand that back in 2002, that's when Enron, the Enron case occurred, the Enron implosion. And you have to understand about Enron. Enron was the biggest privately owned energy company in the world. Enron was worth, as a multi-billion-dollar company with thousands of employees. So when that company was accused of breaking the law, falsifying financial records, and when that company went bankrupt, literally investors lost all of their billions of dollars, thousands of employees lost their job, and even more employees lost their pension benefits and their retirement benefits because the company now was completely worthless. So it was a huge deal. So Congress is going to come in. They enact this bipartisan legislation, say, okay, we want to minimize the risk of a future Enron, of a future financial, of future financial fraud at this massive scale. So what that law basically says, it makes it a federal crime to, when there's a federal investigation, to destroy or conceal or otherwise, tamper with any financial statement, record, or other tangible object. So the government said, wait a minute, Mr. Captain Yates, when you threw those fish overboard, right, you were hiding, granted, not a financial record, right, because that's fish, right? But fish are tangible objects, right? Fish are physical things. Fish are, that's literally under the textual definition of the statute. So, this was a great case because, it's these types of cases where you can't predict how the quote unquote conservative justices will rule or how the liberal justices will rule. What's really interesting here is in this particular case, Ruth Bader Ginsburg wrote the majority. It was a 5-4 case. So the case was, court was evenly divided here, by one vote. And RBG, she wrote this really amazing opinion saying, you know what? Yes, a fish might be a tangible object in the literal sense, but you have to look at the purpose of the statute. And the purpose of the statute was to deal with financial crime, not fish and wildlife investigations of, red grouper. So the majority ended up voting with RBG and saying, you know what, Mr. Captain Yates, guess what? You get to walk. You are slick after all. Your conviction is thrown out because he was convicted in the lower courts on the theory that he was destroying, technically a tangible object to impede a federal investigation. And so in the dissent, though, was Justice Elena Kagan. And Elena Kagan, she's one tough cookie. She was the first female dean of the Harvard Law School. I mean, think about that. To be dean of the Harvard Law School, that's probably one of the highest, next to being a Supreme Court justice, that's a great honor. And she was the first woman dean of the Harvard Law School, which is the most famous, law schools in the country. And so, in the world, and so she worked, after that, President Obama appointed her to the United States Supreme Court, and she wrote a dissenting opinion saying that, you know what, I'm not going to look at the purpose of the statute. Who am I to guess what Congress really had in mind? Congress used the word tangible object. And so a tangible object includes a physical fish. So Elena Kagan, she did what's called a textual approach to interpretation. She said, look, if the law literally says tangible object, I have to apply the law as I find it. You know what I mean? Even if I think the outcome maybe is unfair or unjust. And so that was a really, really, a surprising decision by the Supreme Court. But the larger point is not whether the case was right or wrong. Both Justice Kagan's argument was pretty solid, and if you're more of a conservative jurist, you're going to be more textualist, But RBG, I think her opinion is very good and very solid, right? don't you want to look at the purpose of the statute? What was the problem that the statute was designed to solve? Go back to my example of no motor vehicles in the park, right? That's just designed for public safety. That law can't apply. That ordinance can't apply to an ambulance, because an ambulance, if it's there because somebody had a heart attack or got injured, it's part of protecting public safety. You need the ambulance to come in to save someone's life or prevent, greater injury. So, you have to look at the purpose of the statute. What's really amazing to me about the problem of legal interpretation is that there's no law telling the court what to do. Sometimes judges look at the purpose of the statute. Sometimes judges will emphasize the words of the statute. Sometimes judges will mix and match, depending on the case and the facts and what they think is the just result. You would think judges should be consistent, but what's interesting is that the judges themselves, oftentimes at the Supreme Court level and high court levels, don't agree on what is the best way to solve the problem of interpretation. And that's why it's really important who the president is, because the president has the power to appoint Supreme Court justices. And different Supreme Court justices will not only have different political views, like about abortion and about, other things, gun rights, whatever. Different judges are going to have, regardless of their politics, they may have different opinions about the best way to solve the problem of legal interpretation. Some judges like Scalia and Justice Kagan, right, who we normally think of as liberal, but she agrees with Scalia that you should only look at the words of a statute and not try to guess the intent of Congress, Other justices like RBG says, no, I need to look at the purpose of the statute, even if that means allowing this guy who was clearly guilty, he was caught red-handed throwing the, undersized fish overboard, but without the evidence, where is your case? You know what I mean? And so, so I just want to throw that out there. The problem of legal interpretation, it's going to bedevil any legal system of any time. And that's why you always need to have a good lawyer represent you or your business when you are in a court dispute or you are challenging a law, because you want to have the best chances of winning, and lawyers generally know how to make good arguments, both textual and purposive, purpose of the law, purpose of the statute, purpose of the constitutional provision, or the text of the provision, the text of the law, A good lawyer will try to make both of those arguments to try to win all the judges to his or her side. So that is in a nutshell. I know this has been a lot, but let's just focus on what matters, the big picture. The big picture is that there are three major sources of law: international law, federal law, and of course state, and we can include under state local law. And in all of those three, and we saw three examples, we saw the Wilkerson case and the Florida animal cruelty law as an example of state and local law. We saw the Lujan versus Defenders of Wildlife and the Endangered Species Act as just a good example of federal law. And the federal animal cruelty law that was recently enacted that Donald Trump signed into law, President Trump. And then finally, we saw international law, although in the case of animal rights, it's a proposed treaty that hasn't yet been ratified by the US Senate. So it's not yet part of our law. Finally, we saw that whether you're talking about international law, federal law, or state law, judges really do play a very important role in determining the scope of our sources of law, because judges are the ones that are, have the power to address problems of interpretation. That doesn't mean that judges are not going to make decisions that you agree with or disagree with. That's going to happen all the time. I even gave you example of cases in Module A that personally I don't agree with, but that doesn't matter, right? Because I'm not a judge, and even if I were, I may not have been in the majority. You know what I mean? The point is to show you that law can go back and forth. Law is not always clear cut. Law has many dimensions, and the problem of interpretation is just, it's unavoidable, because you're going to have new situations that the law that was enacted in the past may not have contemplated, So with that introduction, by the way, you should be in excellent position to do now the second discussion post for Module A. I know people are just getting their financial aid, so I'm not going to give any quiz or textbook reading. I'll just write about one of those three cases: Wilkerson, Yates, or Lujan, and just tell me what you think, if it was right or wrong decided. Again, you get points whichever way you decide. By the way, Nicholas, I see a hand up, so please jump in. Then we'll begin to
Yeah, I
wrap
just
up.
had a question real quick. So earlier we were talking about the Facebook ruling and how Facebook is allowed to kind of like prohibit hate speech and everything.
Yeah.
So something that I was kind of wondering, so is my understanding that it's the government's obligation to protect the rights and of people and of the people that it represents. So I wanted to see like kind of where that line could have been drawn because we do obviously have the right to free speech. And since Facebook is such a large platform with being Instagram and Facebook,
Right.
it seems like by them limiting it, they are limiting free speech because if you can't post on these platforms, then you can't get that same kind of word out.
By the way, 2 points. Remember in my last class when our orientation talked about slippery slope? So if Facebook, here's your argument against Facebook's, right? Discretion here. If Facebook really does have the power to basically censor and disregard the First Amendment, and, have their own content moderation policies on Instagram and Facebook itself, then could Facebook censor your WhatsApp posts, or your text messages if you're using a Facebook device? Facebook at one point had these devices, where you could, which would just have Facebook and Facebook Messenger. You know what I mean? So can Facebook censor my private Facebook Messenger posts? Slippery slope would be that yes, right? Because we say Facebook is a private company, can do what it want. So here's the answer though. And it's actually a case that was, speaking of former President Donald Trump, or current President Donald Trump, depending on your views of the 22 election, but here's the deal. President Trump back in July of 2020 brought a lawsuit. No, I'm sorry, 2021, just this last summer, brought a lawsuit against Twitter and Facebook. As you may know, Trump was deplatformed. Basically, he was kicked out of those websites. So now Facebook said they're going to reconsider their decision, I think, in December of 2023. So before the next presidential election cycle. Twitter's ban is indefinite. You know what I mean? So Donald Trump's argument, and I think it's a good argument. Some of my liberal law professor colleagues kind of like, when his lawyers filed that lawsuit, they said that this was frivolous. I disagree because the way that you can extend the First Amendment to these private platforms. Now, the general rule is true. The Constitution only applies to state actors. So the Facebook technically is a private company, though it's publicly traded on the stock exchange, but it's a privately owned company, right? But there is an exception called the public function doctrine. And the public function doctrine is, historically, when you are doing work for the government or you're providing a public function for the government, then the First Amendment and other constitutional rights you do have to respect. Trump's argument, and I think it's a good argument, because an argument I was personally making even before the lawsuit is that to the extent people use Facebook to communicate ideas, right, including political ideas, which of course is what people use Facebook for, among other things, you could argue that Facebook has become a kind of public forum, or you could argue that Facebook has is exercising a kind of public function. Now, that said, let me tell you, the outcome of that case, I do think it's 50-50. I don't think it's frivolous. I don't think Trump's argument is frivolous, but I don't think it's a slam dunk, because here's the problem, right? Facebook, at least, is not getting paid by the government to provide, Facebook accounts. You know what I mean? Normally, for the public function doctrine to apply, it's a company being paid by the government to provide a public service. Then there's no doubt that the government,
Facebook is capitalizing on the ad revenue from government action on.
Oh, true. Yeah, no, fair point. And Facebook does accept, unlike Twitter, Facebook does accept political expenditures, including from incumbents, right? So an argument could be made, but that's why I say it's 50-50, right? Because, but this, so Facebook, yes, you could say it's definitely benefiting, an argument could be made, say indirectly, right? That Facebook is getting some kind of compensation, and benefits, whether it's from accepting directly political ads, or whether, some of the ad algorithms, you can say it's like, for example, I think the CDC, you'll see ads from the Centers for Disease Control on Facebook, right? So you could say that to the extent you're receiving, that's like, right? If you're a college and you receive federal funding, then you cannot discriminate, against women, against minority, against anybody, because you receive federal funding, right? You know what I mean? If you're a private college with no federal funding, you do what you want, but the moment you receive federal funding, even if you're a private college, right, you have to comply with anti-discrimination principles, right? So yeah, that argument could be, and that's why I say it's 50-50. But be fair, it's not a slam dunk. I don't think it's frivolous. And I personally, I think the courts, I might even say 51-49 pro-Trump. The problem is, though, and I'll be honest with you, not to say that I like Trump or don't like Trump, but because it is coming from Trump, you know what I mean? The courts may not give it that much weight, you know what I mean? Like, but who knows? Because, maybe it's going to be a court by a Trump appointee, and maybe a Trump appointee may be more sympathetic, or maybe a Trump appointee, to give the appearance that they're completely neutral, may have to be even stricter, you know what I mean? And so that they're not accused of being, playing favorite. So it's a really, really close, to me, it's a close case personally. It's not a frivolous case at all. And an argument can be made, that even if they're not receiving ad money, and even if they're not receiving political ad money either, I would argue that by providing a communication channel where people discuss political idea and talk about their favorite candidates, and stuff like that, I would argue that to me is a sufficient public function that even if you're not getting paid from the government to do that, I think the court would at least seriously entertain that the First Amendment should extend, to these big tech companies, and that would include Google, by the way, because they, and their search results, you know what I'm saying? That there's, allegations have been made that they're skewed, By the way, Sydney, you jump in here as well. I see you have a hand up.
Oh, I was gonna ask a question about a totally different topic. So I don't know if he's done with his question or not. But
any follow up?
I think.
And then we'll go to Nicholas. Okay.
I kind of just wanted to ask, like, your perspective or your opinion on, like, if there might be any international law on the dog meat industry that's happening in Africa.
Oh, wow, excellent. Well, you know what? In part, the international, and I'm going to ask you, I'm going a little bit, I'm already on a limb using Tiger King. So, so I'm not going to ask you to study the proposed international convention on, animal protection. But just to know that it is there, that would be an example of international law, that international law applies or doesn't apply at the election of each country. But yes, that's one of the reasons why that statute was actually, or that proposed treaty was initially, even put on the table, because of the illicit animal trade, not just like in dog meat and those kind of things, like domestic pets, but also in trading of ivory tusks and, other endangered, other parts of endangered animals, that are valuable for whatever, religious reasons or, whatever, the people are from other parts of the world demand. So yeah, as a matter of fact, and so the question is, what's the best way to combat it? So Africa is a huge continent. Actually, you may not know this because of the way the globe, I have like 12 different globes all over my office here. But if you actually look at China, People's Republic of China, which is a huge country, Africa is even larger than that. It's like 3 times larger than People's Republic of China. So, the thing about it, without an international treaty, how can you solve problems that transcend national borders, right? So that's why that's the argument for the Convention for, protection of animals. But the controversy is the reason why the U.S. Senate, for example, hasn't taken action on it yet, and few other countries have taken action, is because it has a broader definition of what animals are protected. You know what I mean? And it kind of goes back to the federal statute. Clearly we have to make exceptions for some type of animals that are used in the fast food industry. And it's like, in some cultures, I guess you could say, certain types of meats are, like think of horses or whatever, you know what I mean? Maybe that's not what you eat every day, but in other places, it's a delicacy, so what animals are we going to protect? What animals are we not going to protect? So that statute, that proposed treaty probably will have to, go through some more revisions before they, a big country like the People's Republic of China or the United States of America would agree to it, But that's a very good question. And that's one of the reasons why that proposed treaty is out there. Okay. I see Josh. Yeah. Yeah, great question, by the way. Yeah. And I see Joshua's out there. And notice, even though it's international, it's the same questions as the Florida statute, right? How do you draw the lines? And by the way, a quick time out before I get to Joshua, that's probably the most important lesson. Once you identify the main sources of law, and I would say ethics as well, law is about drawing lines, what's on this side of the line that's illegal or generates civil liability, and what's on the other side of the line that's perfectly legal, that you can go ahead and do without consequences. Sometimes that's tough, you know, and that's why you need the Supreme Court and other courts to help draw that line, even if they do it imperfectly. Yeah, Joshua, jump in here.
About drawing lines and what Sydney was talking about, like, where does it get drawn? Because people eat rabbit, you know, relatively commonplace, and that's considered a pet for a lot of households, even here. So, like, why would it be on one household pet and why not the other?
Yeah, excellent example. And that's, you know, to me, Tiger King is literally the gift that keeps on giving. You know, when you look at Tiger King, whether you like it or not, and I find it highly entertaining and in some way poetically beautiful, just because I've never seen such a disparate and crazy group of individuals, you know what I mean? And in some cases despicable. But I have to say, yeah, that's exactly right. You know, that's a great example. I never even thought of that, right? Rabbits, and, you know, there are different kinds of rabbits, there's hair, stuff like that. But your traditional bunny rabbit, right? Like when you think of Easter and those kind of things, you know what I mean? It's actually, you know, a pet. And it's also a delicacy, you know. Now, it's not a delicacy you eat every day, you know, but you know, it's more like quail, you know, and quail, you know, but unlike quail, you know, rabbits are more common pets. So where do you draw the line? And by the way, one of the questions is that you know, let me just be totally honest. Now, this will inform my philosophy of grading. You'll notice, right? You get credit however you answer, because I'm not here to say you're right or wrong. In fact, specifically, part of it is to make it easier for me to grade, I'll be honest. But part of it is because that's how life is. The most interesting questions are difficult line drawing questions. And so sometimes, you know, there's the, you know, the first level question, where do you draw the line? Like, where do rabbits fall? You know, where does dog meat fall? You know, where does horse, you know, that kind of stuff, right? Why raccoons on one side? What about insects and reptiles on the other side, right? Here's the deal. What about non-endangered species, right? Just animals that are plentiful, right? Pigeons, for example. So here's the deal. You and I can have a good faith disagreement about whether we should draw the lines, about whether we should make an exception for rabbits or put rabbits along with raccoons. You know what I mean? That kind of thing. But another question that people often don't think about and take for granted, perhaps the most important question, is who gets to draw the line. So oftentimes, you know, and I say courts play a very important role. In fact, one way of looking at courts is that courts are sort of that branch of government that gets to draw lines. You know what I mean? That's why we have courts. That's one way of looking at courts, because of the problem of legal interpretation, because of these ambiguities, because of your excellent example. But I just want to throw it out there that, remember my first assignment from last week? It's still open if you haven't done it, but also members of Congress, right? The Congress gets to draw lines when they enact legislation. They get to decide in the first instance, is this sufficiently connected to commerce or not? Now, eventually it'll go to the courts if it gets challenged, and the courts will make, quote unquote, the final call, you know what I mean? But members of Congress get to draw the line, you know, as well. State legislatures, right? When they are enacting legislation under their general police power, they've got to draw lines as to, okay, we have a police power to protect animals. Where do we draw these lines? You know, so notice what's really interesting in our system of government is that really all the branches are drawing lines. And you could say that citizens, when they're voting, you know, and exercising the franchise, we're electing candidates that we think will draw the kind of lines that we want to be drawn, you know, maybe mistakenly, maybe, you know, maybe correctly, right? We're predicting how our members of Congress and state legislature will vote. But notice, right, that the courts always play that really huge role, because when there's a dispute about how the line is drawn, you go to the courts. The problem is, once your case gets up to the US Supreme Court or the state Supreme Court, the highest court of your jurisdiction, and you don't like how that court drew the line, where do you go for, you know, help? You know what I mean? And so that's, you know, so that's always going to be one of the dangers, as Hamilton warned us in Federalist 68, that, you know, the courts, you know, could be potentially dangerous in drawing lines, and so we have to limit their jurisdiction. It's one of the arguments actually for having the standing doctrine. Yeah, yes, we want the government to comply with its own laws, but do we want the courts always telling the government what to do? You know, sometimes it's not clear if the government is really complying with its own laws or not, you know? So I just want to tell you that a lot of this, you know, is, like at the law school level, this is what the professors and the students are debating and discussing, not just where to draw the line, but who should draw the line. And if you remember anything from today's class after you finish your discussion post, always remember what I talked about today. It's not just how you draw the line, it's who gets to draw the line. And that's really important, because oftentimes, where you stand, it depends on where you sit, right? And so remember that, it's how to draw the line and who gets to draw the line. Any other questions, comments? This is a great participation, by the way, great group of people here. Okay, let me just look at the chat. Otherwise, wonderful. So we don't have anything in there. Yeah, Yo Gotti is good. His song on LeBron James, one of my favorites. Actually, all of his songs are really good. But my wife has put me on to Yo Gotti. I'm actually a country western music guy myself, what I'm saying? But I appreciate good music wherever I listen to it. Wonderful. Yes, optional lecture. Yes, there will be an optional lecture on Thursday. Now, I'm going to confirm the time. I think I put 6 o'clock or 6:30 because I was invited on a Spanish language radio program at 5. So, but there will be an optional lecture on Thursday. And by the way, this one is recorded. So let me stop the recording right now because otherwise I may forget and then lose the recording. And